right, can you guys hear me there at the Wexford County courtroom?
Yes,
Yes.
we can.
Okay, we just have the prosecutor, is the defense counsel signing in separately? They must be, I guess, they're not there present, right?
They are not present.
Okay, let's just stay on hold then. I don't see them signed in yet, so let's just wait for 1 second here. And we'll see if they sign in. Thank you. I'm going to mute for a second and ask my assistant to contact defense counsel. So it'll just be a minute.
All allergies have kicked in for me.
Okay, apparently the defendant's counsel had some technical issues, so they're going to be signing on shortly. So it should just be another minute or two. Thanks, everybody. Okay, Ms. Meneses, are you able to hear me okay?
Yes, Your Honor.
Okay, all right, we'll go on the record now. This is People versus Shainwald. This is Wexford County case number 23-13713-FH. I'm presiding over this case as I have for some time by assignment. The record should reflect that Mr. Shainwald, the defendant, is present today by Zoom video. If I could have both counsel put your appearances on, starting with the prosecution, please.
Yes, Your Honor. Nate Carnes appearing on behalf of the people.
Angeles Meneses from the State Appellate Defender Office on behalf of Mr. Shainwald, who's present by video.
All right, thank you. So I did have a chance to review the motion in brief filed by Ms. Meneses. Mr. Carnes, I did also receive your response. I had a chance to review that. Today is the opportunity for both sides to present any oral argument. Ms. Meneses, anything that you wanted to present today in support of your motion?
Yes, Your Honor. So we have raised, just very briefly, because I understand that Your Honor has read the pleading, we've raised two issues. One deals with sentencing and correction of the pre-sentence report to omit both acquitted conduct dealing with Mr. Shainwald's other child, Elijah Shainwald, as well as irrelevant, inaccurate information that was not proven beyond a preponderance of the evidence at sentencing. And to the extent that this court relied on any of that information in the pre-sentence report when imposing sentence, Mr. Shainwald should be entitled to resentencing. And then also that the trial court or this court erred when it did not exclude the forensic examiner's testimony, the fact that a forensic exam happened at all. I have attached several concurrences from the Court of Appeals that indicate that it is problematic when that's seen as vouching testimony, when testimony of a forensic exam is allowed to be admitted at trial. Other than that, I would rest on the pleading. And if the court has any questions, I'm happy to answer them.
I don't at this time, thank you. Mr. Carnes, anything you wanted to present today by way of oral argument?
Your Honor, as far as the contents of the PSI, it's a preponderance standard, and they were, I think, properly included, and I saw no reliance of the court on the acquitted conduct. I have no objection to that being omitted from the PSI at this point. I leave that to the court to decide. As far as the forensic interviewing, the witness's testimony in this case did not rise to vouching. Instead, she was just giving the background of the forensic interviewing process, which I think is important and often protects defendants, just to make sure that this process is filed so we don't have something like we had back in the late 80s with the McMartin daycare case where people were using leading questions. Unlike in People v. Douglas, this forensic interviewer did not testify as to what the victim told her during the interview process. She merely explained the interview process. For that reason, I'd ask the court to deny defendant's appeal as to that issue. Thank you.
Thank you. Ms. Meneses, it's your motion. Anything that you wanted to say in response to the prosecutor's arguments?
Yes, I just very briefly, I understand the prosecutor's concern about why a forensic exam protocol is administered, why a forensic interview is given, rather than, children being asked leading questions in cases such as this. However, it's the fact that that testimony was put on the record, and it suggests to the jury that because the case has reached that point, because a forensic interview has been given, it implies that the case is that this person has been investigated, that this person it's reached that point. And it does vouch for the complainant's credibility, that her words were enough to give rise to this forensic interview of Mr. Shainwald, and that's what the jury heard. Secondly, with respect to the pre-sentence report and the information included there, even if the court did not necessarily say, I am relying on this piece of information, this piece of information, and this piece of information, the court is presumed to rely on the pre-sentence report as a whole. And I believe that to the extent that any of that acquitted conduct or irrelevant information was relied upon in fashioning a sentence, that Mr. Shainwald is entitled to resentencing.
Okay, thank you. So I did have a chance again to review the written submissions of the parties prior to the hearing today. The arguments of both counsel are consistent with what they presented in their written arguments. I will say Ms. Vanessas, I thought your brief was really well written, and the arguments were set forth very clearly. So I appreciate that. Likewise, Mr. Carnes, your brief was very succinct and directly addressed the issues raised by Ms. Vanessas. So I appreciate the work of both counsel and the written submissions, which were very helpful to me in preparing for this hearing today. I did have a chance to review the unpublished case that was cited and in particular, of course, Judge Shapiro's concurrence in that case. I think one thing that is well settled and certainly came through in the majority ruling in that case is that when forensic interviewers are called to testify, regardless of the substance of their testimony, it cannot vouch for the credibility of an alleged victim. It can't be used directly to bolster the credibility of a child witness or alleged child victim. And certainly that witness cannot testify or counsel can't elicit testimony from that witness as to whether or not the assaults actually happened or that witness's opinion in that regard. Looking at Judge Shapiro's concurrence, I think he recognized that those are the limits of expert witness testimony and Child Advocacy Center forensic interviewers testimony. I think though, I mean, frankly, I just disagree with Judge Shapiro's stance on some of what he wrote. You know, he wrote that the interview, whether or not an interview was actually conducted by a forensic interviewer and how it was conducted isn't really probative as to whether or not the assaults occurred. I don't necessarily disagree with that as a principle because it doesn't go really, of course, to the underlying facts and whether or not they occurred, but it certainly can be probative as to other issues which I think are relevant. Often, just as an example, and I don't think it occurred in this case necessarily, although it might have, trying to recall all of the defense arguments at trial. But a lot of times, you know, the thoroughness of an investigation is attacked. And so I think to the extent that that's part of the defense case, calling a forensic interview to testify that an interview was conducted, that it was conducted according to the standard practices of those types of interviews involving children, I think is relevant to whether or not a thorough investigation and proper investigation has occurred. So again, I think just to make a blanket statement that it's never relevant because it doesn't go to the ultimate issue, I think I just disagree with that. I also disagree with Judge Shapiro's comparison of that testimony to a polygraph exam. Because again, admissible testimony that doesn't go to credibility or bolster credibility or vouch for credibility directly typically is just, again, what procedures were followed, the fact that an interview took place, and then, you know, the interviewer reports on the information that they gleaned from that interview and then turns that over to police and prosecutor who then decide whether or not what they have is credible enough under a probable cause standard to bring charges and survive a preliminary exam. I think that's much different than what happens in a polygraph where you have an examiner who is providing their actual opinion on the truth or falsity of the statement based on the data that's obtained during the course of the interview. So I think, in my view, those are really different and distinct things and not subject to the same analysis. So I say all of that to say that I don't fully agree with Judge Shapiro's concurrence there and his position, and recognizing that it is a concurrence in an unpublished opinion. The court, while it may be useful in terms of the court's analysis, I don't find it to be binding or something that the court has to follow in this case. So looking at the testimony of the witness in this case, I find that it did not rise to the level of bolstering the credibility of a witness, vouching for the credibility of the witness, giving any kind of opinion as to whether or not the assault happened. And so therefore, I don't think it was admissible on the grounds as argued by the defendant. And because of that, I don't find that it was below the standard of reasonableness and outside the scope of trial strategy for defense counsel to have objected to that or sought to have it excluded. So the court will deny the motion for new trial or get their hearing on that basis. In terms of the issues regarding the PSI, and in the interest of supplementing the record from the sentencing hearing, having presided over the jury trial, I certainly was aware of all of the allegations that were presented to the jury. I was aware of what the jury convicted Mr. Shainwald on and what they didn't convict him on. I was also aware of the charges as they were brought at trial, of course. So to the extent that the PSI referenced any uncharged or acquitted conduct or unrelated allegations, I certainly was aware at the time of sentencing that while those were background facts and in my view properly cited in the pre-sentence report, because as we all know, the rules of evidence don't apply to sentencing hearings or to pre-sentence reports. I think providing all of those facts, even if they related to unrelated or uncharged or acquitted conduct, made up the fabric of the entire course of this case. And I was aware, of course, at sentencing that they weren't the basis for the sentence in that case. And in my view, and for the record again, my consideration at sentencing was solely the conviction by the jury and not unrelated or uncharged or acquitted conduct. I sentenced Mr. Shainwald based solely on the charge that he was convicted of and nothing else. So for those reasons, number one, I don't find that the information was improperly contained within the PSI, again, because it did make up the fabric of the entire case and provided the court with an outline of all the circumstances. But in addition, I did not rely on any of that conduct in determining what was an appropriate sentence in this case. So again, the court finds the motion should be denied and that the defense counsel, trial counsel's failure, to the extent there were any failures to seek to exclude that information, was not below the standard of reasonableness. So the court will deny the motion. Ms. Vanessa, you did provide an order with your motion, so the court will simply check the appropriate box and assign that order as it was presented to you, and that'll be served on the parties. Ms. Vanessa says the moving party, is there anything else we need to address for the record from your side today?
Not for the record today, Your Honor, no. Thank you.
Thank you. Mr. Carnes?
No, Your Honor, thank you.
All right, thank you. That concludes this hearing today. All parties are free to disconnect at this time.